So, welcome everyone to the 7th session of the Rubix Knowledge Series. And this time we are going to be talking about legal perspectives for the new normal. And speaking with us is our expert today, my friend Abhijit Joshi, the founding partner and the managing partner of Veritas Legal. He is one of the country's leading corporate lawyers with a noteworthy career spanning over 25 years. And given the breadth of his practice, Abhijit is uniquely positioned to strategize and advise a broad range of clients, whether it's corporations, organizations, or individuals, on a variety of complex regulatory matters, investigations, and disputes arising under Indian laws. Amongst other accolades, Abhijit has been recognized in the A list of India's top 100 lawyers by India Business Law Journal. And he has been ranked in the band 1 of for corporate and M&A by the prestigious Chambers and Partners Asia Pacific Guide for a few years now. In recent times, Abhijit has navigated some complex matters, including for Deloitte Haskins and Sells LLP in the ILNFS matter, for ICICI in Chanda Kocher's challenge to her termination matter, and has advised Pfizer on a merger with Mylan, which is one of the world's largest pharmaceutical deals. So I think we're very fortunate to have someone of Abhijit's experience here. He is, as I said, my friend. He was a senior and fellow alumnus of Sydenham College of Commerce and Economics, and inspired me because he was one of the youngest chairman of the Students' Union in Sydenham, and inspired me to follow his footsteps a few years later. We're also fellow members of the YPO and the EO Entrepreneurs Organization. So Abhijit, welcome. Rubix welcomes you to the show. Everyone's very eager to hear your views. And thank you for agreeing to do this.
Thank you, Kaushal. Obviously, you didn't follow footsteps. You are wiser than me. You didn't become a lawyer.
Well, yeah, and I know it's difficult to catch you on a Saturday because, as you've been telling me, and as we know, investigating agencies are very busy on Fridays, even despite the lockdown. And Saturdays then tend to be busy days for you in terms of some of the issues. So I'm going to ask you a broad question. How has the legal system in India responded to the COVID pandemic? Are courts functioning? How close are they functioning to normal levels before the pandemic and the lockdown?
So, Kaushal, I think first your question is if it's limited to court, let me answer the court part. I think courts have been actually this time, it's an exception because even in emergency, you had faster disposal of matters than what you see today. And that is because courts have been very slow in moving to the virtual platform. Some courts have done better than the others. And what is happening is that suppose they were disposing 100 cases, probably they are disposing 10 cases today, and only urgent matters are being taken up. Now, to every person, their own matter is urgent. But the court sees, so just to give you an example, today, God forbid if anybody gets arrested, bail is not a matter of course. Not because your case may be good or bad, because there is nobody to hear the bail. And only in emergency, very, very urgent cases, they will hear bail. Now, what is urgent and what is important and who is and who's not, and the vast country like ours, something like that being denied. Of course, commercial causes are suffering a lot. But good part is hopefully sanity will prevail and people don't fight as much because they know that justice is not only delayed, but at this point of time, even denied. So courts have not done that well. So if you see on the Western side, like I was talking to people from London and, their courts have functioned pretty well. The US courts, not as well as the English courts, but still functioned well. And there's, things to be achieved on that part out here. But if the other part of the legal profession, you are seeing that deals are going through. All the Reliance deals have gone through. Historic amount of money has come in during pandemic. So
Come in,
that part
yeah.
is going very well. I think the advisory and the transactional part is going very well. The dispute resolution is somewhat suffered. Even arbitrations are suffering because arbitrators are not sitting.
Okay. So you think that more could have been done in that area?
Yeah. I mean, more could have been done. I think the courts are not equipped to go virtual.
Correct.
Right.
Correct. So I think
Platforms
it
really
also, yeah, I think like all of us in companies where we had all explored remote working but hadn't done it to the extent because it wasn't forced on us. Hopefully the courts and the legal system will also sort of take a cue from this book and have to do that in the days ahead. So that's a good hope, and that augurs well for disposal in the future, hopefully, in the event of this continuing.
Yes, I think, and as I said, some courts have done well. Supreme Court's doing well. Delhi High Court's done well. Some courts have done well. Some courts have not done well. So, but it's not a happy situation.
Okay. This question has come from a number of promoters, CEOs, and non-executive directors. What is the liability of promoters, management, and non-executive directors in the event of a COVID outbreak in their factories or workplace? Are they liable in any way under health and safety law or under any consolidated lockdown guidelines that are prevailing in their location? How can they minimize the legal risks?
So, the government has given a lot of do's and don'ts and guidelines in terms of social distancing and masks and this, that, etc. Arogya Setu app. And so, as you know, if anybody wants to go, just go on our website and it'll tell you what are the current regulations under the Disaster Management Act. Each state has then also given what they need to do. Now, the primary liability of the employer is that if they open the offices but do not follow these regulations, then that can result into some kind of action under the Disaster Management Act, and that is where the liability. But under general law, the closest is the Workmen Compensation Act, but that's in relation to an accident that occurs during course of employment, and that too in relation to workmen who are defined under Industrial Disputes Act. But specific to the pandemic, I think everybody should follow that regulations very carefully. And also you must realize that this is all under Disaster Management Act, which is a very special act, and they have criminal implications. And therefore, those you just have to follow that. But I doubt on a practical level that after following all that, if somebody gets something or there is an outbreak, anybody is going to be blamed beyond a point. But technically, yes, just have to follow those guidelines.
So I know someone, Abhijit, who yesterday they were supposed to be, in Maharashtra where there was supposed to be some testing. And when the testing was supposed to happen for all their activity, all their workers, they were advised by the, relevant authorities, competent authority, as you lawyers call it, that, please, if you test everyone, then you have to be prepared to face the consequences in terms of if there is a large number of people, we will actually have to shut you down. So it's a sort of a double-edged sword where people, want to test and at the same time are being prevented because it could end up stopping their activities because of, confused guidance. So any thoughts on that, what people should do?
So I think, Kaushal, there are two different things. One is a commercial exigency, and the practical aspect of it, that if you test,
Right.
There will be a business disruption. And second is the legal liability. Let me deal with the second first.
Correct.
For the second one, I think you just follow the letter of the law, which is the social distancing, which is whatever 10% or 10 people or etc. Whatever is laid down, and that should suffice. Now, you want to go a step further because this is a very low grade of clinical prescription. Most of the corporates would be doing much better than that in terms of, because everybody's worried about their own personal skin as well. If people are coming, then at somewhere, the bosses are also coming for some time, etc., etc. Now, that's where it goes into the realm of commercial exigency. When you start testing, then there could be somewhat people, and then you may have to shut down, etc., etc. Now, that's a business decision. The government
Right.
is not asking you to test everybody. But as I see it, it's an up and down world over. So you will do it for a while and then you not do it and then you'll shut down and then you'll open and you'll open. I think it's up and down situation. And that's the new normal, I guess.
So it's the new normal, right? Right. Right. So, talking about the new normal, a lot of people and folks, please keep sending your questions on the Q&A tab. Some of you have already sent them. And I think it'll be great if you all continue to do so. And I'll ask them to Abhijit. So, in the initial stages of the lockdown, there were a plethora of issues arising from the use of force majeure in a wide variety of corporate contracts, Abhijit. We heard about a lot of cases where force majeure terms were invoked. In fact, I know I heard you speak at a couple of webinars on that. Has that trend slowed down now? What sort of protection do you recommend that companies and businesses build into their contracts to prevent force majeure from being used to their detriment?
Again, Kaushal, there are a lot of questions within your question. So one is how the courts are interpreting force majeure. And when this pandemic started, we didn't know because the law is very clear. Force majeure has to be interpreted strictly in terms of its contract. It's not a statutory provision, unlike many countries like Germany and China, etc., where it is enshrined in the statute. And therefore, it's contract to contract. And the courts would read it strictly. If it's there, it's there. And if it is there, it depends on how it is drafted. Now, we thought that the courts will start reading equitable proposition, especially when, the migrant labor crisis and all this was happening.
Right.
But fortunately, the courts have stuck to the law. So what the cases have evolved in the last 3-4 months is that courts have gone by the contract and courts have gone by the clauses that are there. So as far as the jurisprudence is concerned, it's clear. You have the force majeure or you don't have the force majeure in your contract. And if you have it, read it. Whatever it says, it says. The problem is here because a lot of these did not contemplate pandemic. A lot of them, you never concentrated on force majeure clauses outside of infrastructure contracts, etc. So therefore, they are not, very well drafted depending upon what hat you are wearing. Your second question. The second question is in terms of how to
what
draft
can be
this
done
going forward.
Yeah, exactly.
So I guess first of all, you have to see what hat you are wearing. You are the recipient or you are the enforcer, and therefore, depending upon that, you have to start negotiating your force majeure contract. Start including pandemic. Start seeing that how long the force majeure continues. Start seeing that what is. So force majeure typically implies impossibility, that you cannot perform the contract because you cannot use the property. Or now the problem out here is that people are not using the properties. They are coming and going. They are just suboptimally using the properties. So you have 2 offices. One office is shut. The other office is only 10% functional, but you have to pay 100% of rent. I'm just giving a rental example.
Correct.
And therefore, now going forward, you got to start capturing those positions also, because it was meant for 100% capacity. You are paying for 100% capacity, but utilizing 10% of capacity, and that too can go up and down. So that's something that you got to factor. So I think one has to adapt out here. So there's no shortcut. I think you got to think through when you're drafting contracts.
Right. So, there is a very interesting corollary to this question, Abhijit, that comes from Mr. Naishad Ashar of Logistics Integrated. And he says that while there is a national shutdown has been sort of unlock phases have happened and they're slowly eliminating or removing the impact of the national lockdown, yet the supply chain remains impacted because, different parts, different states are doing different things, different districts are doing different things in some case. Are these grounds sufficient to invoke the force majeure clause, if it exists, as a way for allowing non-performance of contract?
I mean, as I said, it depends on the contract, but my gut says no.
Okay.
because this is not a frustration of the contract. This is not an impossibility of the contract. It's just that you are not functioning as you could have. This is force majeure is typically not meant for difficulty. Force majeure is not mitigation. So every time you make a loss, it gets adjusted. This is not a adjustment mechanism. Force majeure is something that cuts to the root of the thing that you cannot perform the contract. Typically, I put it in a very layman word.
Right.
Words, but that's what is meant to. This is not give me relief because I'm going through difficulty.
Right.
Unless you drafted as such, and unless a counterparty has agreed as such, which is very, either they've got bad lawyers, or they've got no lawyers, or they've not thought through. Because
or you're their lawyers and you've done a damn good job of drafting it.
No, probably the other side has not thought through more than the genius of the lawyer who's drafted it.
Okay. There's another question that's come, that a lot of cases where people have invoked the material adverse change clause in order to get out of their contractual obligations. So could you please talk a little bit about this clause, material adverse change, and how it differs from force majeure and the kind of situations in which it can be used? And if you are at the receiving end of this clause, how do you protect yourself from it?
So if I'm at the receiving end, first, you got to do what most people don't do, is read your contract. Read it again and read it again and read it again. Right? Material adverse change or material adverse effect is distinct from a force majeure. Force majeure, as I said, it's something that almost leads to an impossibility.
Right.
Material adverse change is something that is basically to say that where the business is materially impacted. Now, the way you draft it could be different. It could be a material adverse change in relation to political instability, in terms of to the financial situations, in terms of economic situations, such that, for example, there are objective clauses to say that it results into 10% of erosion of net worth, or it results into turnover, which is so it depends on how you define that. So it is far more a commercially carved clause than a force majeure proposition, and therefore everything depends on whether you can or cannot invoke what's written out there. Is it French or English? So it's a much wider clause typically when it is drafted. And if you are on the receiving end, then, and if your contract is fuzzily drafted, or this particular clause is fuzzily drafted and it's a little subjective, in India, there is no really case laws which tell you what is a material adverse effect.
Right.
So suppose you said that if there is a material adverse effect, I can get out of the contract, but you not defined what material adverse effect is.
Right.
Which is not many times people define it. And if you want to get out of the contract, saying now you don't want to conduct this seminar, but I want dressed up and nowhere to go, and you said no, now I don't want to conduct the seminar, and there is an MAE clause out there, then the jurisprudence on the subject in India is very poor. But in America, in the US, it's a well pronounced proposition, and material adverse effect is that which cuts to the substratum, the root of the proposition. So it goes closer to a force majeure. But that's the jurisprudence, US jurisprudence. But at least in my experience, whenever there is an MAE used, they are usually defined. And that has got to do with some business parameters.
Right. Yeah, because a lot of people on this call are also, we have folks from ECGC, which is the Export Credit Guarantee Corporation. We have a lot of exporters also who deal overseas. And usually, these clauses in American, contracts, these are standard clauses. So you just sign it because you want the business and you don't really get into some of it. I'm a garment exporter. I'm looking at it. I just sign it. But later you're saying that in the US, it can, under US law, it's better defined. The jurisprudence is clear. Is that what you're saying?
Yeah. No, I won't say jurisprudence is clear, but the jurisprudence is clear on what is the MAE. Now, of course, it's case to case, etc. And, I know what people just sign contracts because nobody wants to go to a lawyer, especially when things are well. Nobody thinks that they should be paying for a lawyer. It's only in bad times that you realize that you should have gone to, because that mistake actually can cost you.
Yeah. Correct. So, Abhijit, I also know, that you're a big believer in negotiated settlements rather than litigation. That's been one of your calling cards in terms of, telling people to try and resolve things. what are some of the key things that people should keep in mind when they're negotiating regular commercial contracts in the current environment?
Yeah, so Kaushal, I mean, you know, so it cuts against my own business case when I say I should negotiate. But I think constructive advice is the correct, because I think in the cost of litigating, and I'm not talking about just the cost of litigating, and people often forget the time cost. And then they value your fees are expensive or not expensive, but the time cost is actually more than anything else, because it goes on and on. And even if it's an arbitration, it's still 2 years you're talking about in effect, 18 months and plus. I would think it's a good question. I would think that in current situation, if you're negotiating a contract, the current situation might be such that one of the parties can exploit the current situation to strike a bargain. I would just urge that party, if there are parties on that, to not to stretch it to a level that you want to squeeze out the last penny. Because then what happens is that you have done a contract which is so tight that the other guy has no breather. So I'll give you an example. I was negotiating my own contract for my office rental, because it came for renewal right in the middle of the pandemic.
Right.
And you come to my office, it's a nice office. We don't want to
lovely
go
office. Yeah, absolutely.
So it's also, and I don't want to fight for so I said, okay, I mean, our business is also getting impacted, but we said, okay, let's get it done. And then it just goes on and on and on. And they said, no, you got to pay more and pay less and pay more and pay less. So what did I do? I said, look, you want the money, you want this, I'm not going to struggle on money, but I'm not going to give you a lock-in, which means I have a right to terminate. In 1 month, 2 months, 3 months notice, I'll get out. So you are making it so tight for me that I want my freedom to get out.
Correct.
Now, if I was to negotiate for the landlord, I would have said, okay, what do you want? I'll give you, but give me certainty.
Correct.
Because at this point of time, if I was a landlord, I would have said, I'd rather make 20% less, but I have certainty on cash flow over, especially if I've got a good tenant, I should have a certainty of cash flow over 1 year or 2 years.
24 months.
So let me lock this guy in.
Right.
So I think you got to think through that, because in order to squeeze the last mile, because everybody's so fixated on what you're getting and what you're not, that they completely miss the part of a good counterparty, a counterparty which will pay the money, and continuity, and tying your cash flows with these counterparties.
Right.
So that's what I would think. If I'm on the exploiting side of this pandemic, I won't stretch the last mile. Correct. So that's what.
No, I think that's good. I think that's great advice. And now on the other side, there's a question from Chaitanya, and the question is that obviously very turbulent times, lots more, a lot of more disputes being created. This is one of the most uncertain times in our generation. Do you expect to see a tsunami of disputes germinating from this pandemic? And what are you advising your clients who are considering pursuing legal remedies? So again, a good question. So in our profession, a lot of people are going to say, let the court open, there's going to be tsunami of this. My take is actually contrary. Okay. So if I see the disputes that are arising because of this pandemic, like the labor dispute or this force majeure type of dispute, etc., I think people will realize, taking color from my previous answer, that if there are two logical people, they will come and settle somewhere and finish it off, rather than litigating for this. Secondly, as I said, look, 4 months back, you and I did a force majeure. Correct. Webinar. Yeah. And at that point of time, I was not sure how the courts will interpret it. Now it's sure the court is interpreting as per the contract. So now if I've got a weak force majeure clause, I don't want to fight with you, actually. Correct. I want to settle. Correct. So I think the court, that will also start evolving. So
I would think I would remove all the logical parties outside this tsunami.
Right.
Then, of course, there is some amount of stupidity that prevails in the market because somebody is, that gives rise to X amount of litigation. But the majority of litigations are going to be people who are just cannot pay. So if you are at a situation where you just can't do anything and then you have to fight.
Right.
And people feel that, the lawyers are going to have a great business case. And I think I'm contrary to that as well. Because it's predominantly a fight between a person who can't pay and a person who's not received his money. Correct. And the lawyer is expecting that in this tsunami, he will churn out his money. So it's a bit of a fool's paradise out there.
Correct. Correct.
So I don't think there's going to be a tsunami. Obviously, something like this will give rise to some amount of disputes. But I think a lot will also, I would just encourage to just sit down and, talk. And if it, of course, it doesn't work, it doesn't work. And also, right. I've noticed one more thing in situations where people, there was a previous question about logistics and the supply chain.
Right.
Is that when again, sorry, I'm keep coming to giving you a real estate example. When you say, okay, why don't you, if it's that bad, why don't you just give up the place?
Right.
No. I don't want to give up the place. Yeah. Even the theater owners, for example, the guys who have leased out all these. They are also not giving multiplexes. They are also not giving up. Because we know that, the whole humanity is not going to die. There will be a vaccine someday. In a year's time, everything will be out. But if these are flagship places, you lose them, to get it back is going to be difficult. So, right. People are also trying to strike a bargain. Please look at my difficulty. But the other guy is also going through difficulty.
Right. So, talking about difficulty, it brings me, to a question that is actually close to my heart. At Rubix, we spend a lot of time looking at credit risk and default. This is what we do for a living, as you know, Abhijit. The Insolvency and Bankruptcy Code Ordinance 2020 of June 5 rather, has suspended the initiation of corporate insolvency resolution process, the CIRP, for 6 months owing to the pandemic. So what are your thoughts on this? While some relief, in my opinion, is warranted due to COVID, do you think that a blanket suspension for 6 months is appropriate? Because aren't we just kicking the insolvency can down the road for some companies and creating a much bigger mess in the process?
So, Kaushal, you have very narrowed the question in terms of bankruptcy. The answer is somewhere in a much larger realm.
Okay.
Are we not kicking down the can in everything?
Whether that's philosophy,
whether it's macro. No, it's not philosophy. It's macro. Are you talking about macroeconomics? Are you talking about inflation? Are you talking about the way courts have dealt with at this point of time? They've given blanket injunctions on things saying that till the pandemic don't come, period of limitation being suspended. So everybody is kicking things in every economy. This is just another kick that you had on insolvency. So I think everything is being kicked. Insolvency is just a manifestation, just an element of it. And the real hard problem is going to be when this is over, frankly. Right from bankruptcies to inflation to defaults, everything will start.
But if you're the chief credit officer of a bank or an insurance company or, NBFC, what do? You want to enforce your rights. You know what the problem is, but you can't go out and do it right now because, you have no legal ability to do so. So,
that's what do you do? Kaushal, we started with it. If you get or I get arrested, there is no bail.
Right.
In this time, judges don't want to sit. How are you going to run an insolvency process, even if, let's say, it was not kicked down, the can was not kicked and everything was open? Where is the NCLT open? How many cases are they taking? They are not taking filing. How many cases are going to be heard? The video links are so poor. You go to one of the video links. Sometimes the fan is going round and round. Sometimes somebody's eyebrows are stuck. So what are we saying? Okay, chalo, let's enforce it. It's not going to happen because the system is down.
Right. But
this, to my mind, is just let them open up, but still nothing will happen.
Right. Well, the challenge is that, still the banks will have to report the results every quarter. The NBFC has to report, and the street, ask them to report their this, and they're not able to sort of show it. So I know you think I have an empathy for bankers, but I do, because this time they're stuck between a rock and a hard place at this point.
Yeah, they are. But at the same time, today, likelihood is that all this non-compliance is not likely to be questioned beyond a point, because everybody has a ready answer of the pandemic.
Right. Another nuts and bolts question for you, and this one is close to my heart. Unfortunately, bouncing of checks, as we all know, is a common occurrence in India. And Section 138 of the Negotiable Instruments Act allows for someone who has bounced a check to be imprisoned up to 2 years. This serves as a deterrent and also provides some leverage to the payee or the person holding the check. Now, in this pandemic's business relief measures that are proposed in June, they're proposed, they're not yet, the law has not yet been passed, or no ordinance has been passed. The Finance Ministry is proposing to decriminalize check bouncing, and there is no imprisonment for someone bouncing a check. Do you support this? Don't you think it harms the creditor or a person who's holding the check? I'm asking this question for a reason. We do a lot of work with companies that take post-dated checks as their security when they're giving credit, right? Even retail, you look at pharma, you look at retail, you look at any large distribution thing. Distributor का checkbook हमारे पास पड़ा हुआ है, signed checkbook, PDCs है, we have nothing to worry. Now, what is the purpose if you can't take any action? Sorry, I'm very passionate about this subject, so I'm asking you this.
Yeah, but now it's only online transfer, Kaushal. Checks are physical. You got to touch it and deposit it. Also, no. So I'm just telling you. See, again, as I said, there is a large part of retail business in B cities, C cities, etc., where the payee feels that he's got a security, and the payer feels that he may go to jail, and therefore, in this understanding of things, transactions go through and the payments are made. But let me take the legal part of it. In the last 10 years since this, at least I have hardly seen somebody being put to jail in 138 cases, because the 138 case also drags on for years and years and years. And sometimes, at the lower cases, at the lower level management, at police level, etc., 4 days of remand can happen, etc. But typically, I'm sure there are lots of cases, but it takes that much time to litigate and bring a man or a person behind bars. So to my mind, this post-dated check was always an illusion as a security. So as you see, post-dated checks taken as security in a lot of retail transactions. But as you start moving into corporate transactions, right? Why don't I give you a loan of 100 million and give you a post-dated check? Why don't you take that as a security on 100 million? You will never take that.
Correct.
5 crores, 10 crores. Why don't you take the checks? You won't take it. You will want my house on mortgage. You will want something more, etc. Because it just takes that much. So I understand that large part of retail business can get affected mentally, but legally speaking, I don't see much of a difference, because to my mind that never was a security in this. Of course, now that if it is taken out, then even in retail cases, the cost of doing business will be higher, because now you have to give some guarantee or money or bank guarantee, etc. Everywhere it's cost. And the government also swings from criminalization to decriminalization. There was a move to make the entire Companies Act, whole host of sections with criminal implications. And suddenly when they want to move, they'll not only decriminalize the Companies Act, but they'll go and change the Negotiable Instruments Act. So unfortunately, in this country, pendulum keeps swinging to extreme to extreme. But yeah, at a lower level, there could be some amount of impact on cost of doing business. But actually, at the crux of it, as a lawyer, if you told me, I'm giving a loan and he's giving me PDC, is it all right? I would have never advised him that yes, it's all right. I would have said, either take a higher rate of interest or get a counterparty which is good, or take a bank guarantee. But this is like an illusion.
Correct. Sab Maya hai.
नहीं सब माया नहीं है. अगर the guy who's taking is a maya, the guy who's giving is a maya, then it's okay. Maya, they will not understand what's going on and he will pay in the fear of me. But if you really take it to court, it's a maya.
Right. There's a question from Ashwin Balakrishnan of Barclays. Do we see a rise in arbitration and conciliation proceedings more during these times? And the other question, which you partly answered earlier, is that if this lockdown continues and all of this continues, unlockdown, lockdown, whatever you call it, do you see that the quantum of digital hearing by courts and tribunals will increase?
So I think there is a rising trend of arbitration and conciliation in any case.
Correct.
Because now under the new act, the arbitration have to conclude within 18 months. Otherwise, there are penalties on the arbitrator, etc. 18 can become 2 years. You're never going to see final justice in 2 years in the court. So I think things are moving towards arbitration much more. In this time, even more, because I think the arbitrators are more functional than court today. Because they are private hearing, you want to align, but they are also impacted. So as a general trend, I think so it will move towards pandemic or no pandemic, it will move towards arbitration. At least the more sophisticated contractual relationships. Bill of lading or a letter of credit, etc. may not have arbitrations beyond a point, but I'm just saying from a banker's perspective, something that, let's say Barclays would see, there would be more arbitration. That's what and the courts moving towards more digitalized. I think it will move. It has moved already. So, but I was on a some 10-20 law firms got together and say how the courts are going to function. So we had all these senior partners from different firms and all that. And we realized that all the top firms that you're talking about in India probably constitutes 20% of litigation. 80% is like your 138 answer.
Right.
80% is conducted in lower courts. This audience is not connected with it.
Correct.
Now, when that mass will move toward digitalization, I don't know.
Right.
So they are not equipped.
Right.
So maybe the 20% of team, top litigation and top courts can move a little bit of digitalization. As you go down where the bulk of litigation is, I think that will take time. So unless the bar councils move, there's a whole political stuff around that. Yeah.
Right. There are a couple of questions around M&A which I've sort of combined, and I know you love mergers and acquisitions. It's your forte as well. So some buyers who have entered into M&A transactions at pre-COVID valuations may wish to terminate the transactions or renegotiate the price prior to closing, and they want to do so without incurring any liability. On the other hand, sellers may wish to proceed to closing, and they're looking at forcing buyers to close. In the current environment, what advice do you have for the parties who are engaged in this M&A transaction, buyers and sellers?
So that's when people negotiate my fees, Kaushal, I tell them that good, cheap, and fast, all three are not possible. You do the permutation. What is good is not cheap. What is cheap is not fast. So you will only get 2 out of the 3.
Correct.
Right. Now your question is like that. Give me a summary of this. What can I do from a seller side? What I can do from the buyer side? What should I do? But let me give you some thumb rule. I can only give you some elementary propositions out of my experience. And obviously, a pandemic experience is limited. I mean, not limited. It's not non-existent for all of us. But typically what happens that when people stretch it to a level, how do I feel it? If a purchaser actually says, okay, let me, first of all, as a matter of fact, 90% of deal are getting retraded today. And that's not because the buyer wants to, the seller wants to squeeze value out. Just the projections have gone totally haywire of businesses. So whatever multiple that you were paying prior to pandemic, those same businesses, the projections are completely different. And therefore, there has to be a realignment of price. So I would think around 90% of the deals are being retraded at this point of time. Now, whether it's a retrade of a previous deal or whether it's a new deal that you want to strike, the question is, I believe that if you're waiting for the bottom, you're creating competition. So those buyers who are going to say, obviously nobody knows the bottom, that's a philosophical thing in life.
Correct.
But everybody's searching for bottom fishing. But if you wait really for the bottom, so let's take this thing. If you are waiting really till Oxford is just about 2 weeks of announcing the
vaccine,
so either you have lost your price or you have created so much of competition on a good asset, because a good asset will start having competition at a particular price. And therefore, you have just lost that particular asset and therefore, I think if you are a buyer, at some stage you'll have to say this can go down, but I start evaluating the quality of the asset. If the quality of asset is good, if it aligns with your vision and the business strategy, I won't wait for too long at this point of time. Because we all know the world is not going to come to an end.
Correct.
We all know that there is a 95% chance that we will all survive and we are not going to die, even if we get COVID. And it will come back. So I won't, if I'm on the buy side, I wouldn't squeeze them on price beyond a point. 2, if I'm on the buy side, I'll come to the sell side of it. But if I'm on the buy side, people come and tell me, I want a damn tight contract because things can go wrong. And this guys, I want reps, warranties. I want a, charge over his burial ground, family burial ground, and this, that, and etc. So people come and say, because we don't know how what's going to go, etc., etc. And I keep telling them that square root of 0 is 0.
Correct.
So you have retraded this deal and you got the 30% discount on this deal, because obviously the guy has given you 30% discount because he has no other, his back is towards the wall. So now you're going to squeeze blood out of rock now, because what you're going to do is that now this guy who's already in distress, that the money is you're going to give him is going to actually go out in his debt payment, and therefore that he can get some more oxygen. You want a tight contract from him, reps, warranties, indemnities, etc. It has no meaning because square root of 0 is 0. Your money is come and gone.
Right.
So you might as well bargain a better price. It comes back to my first question. Now, in the bargain of the better price, don't squeeze so much that you lose the deal. So there is a balance out there. Because people who want to exploit this pandemic want to exploit to the fullest. Right? So that's on the, I don't think that buy side, because this tight contract, etc., beyond a point doesn't work, because who's the counterparty is very important. Now, if you are dealing with the Tatas or the Birlas, they'll pay. But then they're not going to give you that tight contract because they're going to bargain well. But anybody who say, okay, give me a page and I'll sign, there's no meaning. They'll sign whatever you want. So you should know what to bargain for and what to negotiate. And in this time, 90% of the time is the price. On the sell side, I would think the very flip side, I would not struggle with if I'm a promoter. I would say, look, am I a short-term player or am I a long-term player? So I would rather tell him that, look, I will not be able to give you all this reps warranty. You cut the price a little bit because I want to sleep well. But if you are that kind of promoter who want to say it doesn't matter what you give because you're never going to fulfill that, then you might as well give and don't struggle and don't pay your lawyers that much. You give it, get a better price, and then you live another day and see what happens on litigation and things. So there are insurances that you can buy on the rep warranties, etc. So I, as a sell side, I won't struggle too much. And I would see the time cost of the money, because whatever you are struggling at this point of time, if you get that money at this point of time, probably what you can do with that money is far more than the incremental cost benefit that you can derive with protracted negotiations. And also there is that.
Oops, I think we lost Abhijit. He's back. Sorry, we lost you for a second. Yeah.
Sorry. And going forward, you don't know whether it's going to go up or down, right? So you are thinking that things will be better, and therefore it's your question about kicking the can. Because if
Right.
you are only kicking the can, vaccine will come, but also a lot of miseries will unfold thereafter economically. Therefore, the buyer is not going to be there because your projections are going to get worst hit at that point in time.
Right.
So I would think a bird in a hand is what two in a bush at this point in time from a sell side.
I think that's a great way to summarize that. Bird in hand on both sides is worth two in the bush. I think that's perfectly put. It's interesting that you mentioned insurance. We have a lot of senior insurance folks on this chat, insurance brokers. There is Arunachalam and Mr. Jairaj of Bharat Re. There is Mr. Umang of Origin Insurance Brokers. They're all very large and sophisticated insurance brokers. And I think there's a bunch of questions coming from them. And that one of the questions is that, during this period, we've seen just before, we've seen the Vizag gas leak that happened. And is it right in law to arrest and imprison the CEO or the MD or senior management of a company when, on the other hand, someone like an body like the National Green Tribunal has ordered a payment of 50 crores as an interim relief or interim compensation to the affected parties? So what is the defense available for senior managers or senior management in such situations? This is from Mr. Arunachalam of Bharat Re.
See, the gas leak, there is a concept of absolute liability. So typically, liability doesn't transpose to shareholders, doesn't transpose to upstream. It's at a level of the person who was in charge of it. If it is a CEO, it's CEO. If there's somebody who's in day-to-day charge, if there's an occupier of that property, and whoever is in charge of that particular property, that's where the liability should lie. But in cases of absolute liability, and the gas, you see Bhopal gas leak, then they have lifted the corporate veil and travel upstream.
Correct.
So often in these kind of situations, I would say there is a lot of emotional aspect, which the equitable aspect of it takes over in the immediate. So if the CEO is arrested, but he was not in charge of the thing,
right?
The chances are that over a period of time, when it settles down, he's going to get bail, though it may not have been right to arrest him.
Yeah, but sorry, I'm interrupting. But if it's during the pandemic, it could be 8 months or 6 months.
Yeah. But there are a lot of under trials who die, under trials who never get relief. That's what I started with. Today, the bail is not, it's just not available. That unfortunately, that's a jurisdiction risk. And that's the reason, people are, see, it's all vexed, right? And the foreigners don't want to come because the jurisdiction rich like this. And then you want to decriminalize situation because people are scared and, and then you decriminalize to a level that so it's a vicious cycle. But coming to the point, whenever there is absolute liability, where there are deaths, right? So, just now in Mumbai, there was a building collapse.
Correct.
They have not picked up the landlord, but they may pick up the landlord, despite the fact that this building that collapsed in Fort they were given notice of vacating people. The authorities themselves were to, now, if people don't leave and they still stay and they died out there, how is landlord liable? Because you yourself have given notice of eviction.
Correct.
But the whole emotion is pick up the landlord.
Right.
So I think if you ask me in law, I can't comment on this particular case because I don't know who was in charge. But let's say CEO was not in charge, then probably it's a wrong pickup. But please expect emotion in this country to run high in cases of absolute liability in this country.
Right. Okay. There are lots of questions coming in and, but I wanted to talk to you a little bit about the legal profession in itself, because we also have some lawyers, some people from Singapore have dialed in, etc., and are very interested in the Indian law or the Indian legal scenario. So, how do you think that the legal profession and firms will change as a result of the pandemic? We are already seeing remote meetings becoming the order of the day. As you said before this call started, first time you won a jacket in 4 months. Even courts are hearing cases on video calls, albeit patchily. But what else will change, and how should law firms prepare for these changes? I know you've built a fabulous company and a fabulous firm rather in Veritas. So how was someone like you who's forward thinking looking at making these changes?
See, Kaushal, there are only two kinds of people. Those who don't know and those who don't know that they don't know.
They don't know.
Let me make first confession that I don't know. I think there are all these several papers that are happening, and I'm saying so because you asked about my industry. There are several papers floating. This is going to happen. The economics will change this way. You should be doing that. Nobody knows. It's been 6-7 months and world does not have a cure. United States of America is throwing 77,000 cases a day. The superpower. Nobody knows how this is going to go. Right? So I frankly don't know how it is going to change. But some trends are evident. I think the whole reluctance of the legal profession to say you cannot work from home because it will not be that efficient is going to reduce. Right? Especially if that is supported by cost savings of, infrastructure, etc. I think, and therefore that some part of it is going to go that way. I don't think so. Litigation is going to go virtual in its totality. I don't think the basic emotion of interacting with people is going to go away. You and me, we can keep meeting on Zoom, but I think there will come a time where you will say, okay, let's get a drink together.
Correct, exactly.
Right. So this may become virtual actually faster and digital faster, but I don't think everything is going to change that fast. In terms of impact, it's frankly, I'm at a loss in terms of what is going to happen. Should we, I know there are things we should be employing AI and we should be doing this. And so we conducted a survey. We conducted a survey with our 20 clients, just 20 clients. And we asked them that forget about how I am going to change. I've asked them, these are my top 20 clients. What would you want to see in us change? And let me tell you, most of them didn't want anything to change. So they said, okay, can I employ more technology? Yes, maybe. Do you want better cost? Obviously, but I think the core was that continue to provide me the quality that you are providing. And the rest was okay. Right. So I really don't have the answer. Actually, how the profession is going to change.
So let me probe you further on it slightly differently. So first question, someone's actually asked it. Do you see in India opening up the market for foreign law firms in the near future?
It's 5 years.
Could be someone.
It's 5 years. 5 years every 5 years.
Or T+1.
If you ask me, I have gone on record to say that it should open up. Because if India is going to become 5 trillion economy or even closer to that, I don't see why, in terms of service provision, the centers of excellence in the world should not be at your doorstep. And competition will only create better quality. For example, today, if you have an oil and gas complex contract, our profession is not equipped. People are going to Texan firm to do Indian deals because there's just center of excellence doesn't exist in India. The markets are not that deep. You can develop oil and gas technology, but you will not have work because how many such contracts are there?
Are there. Yeah. So, probing further, there's a fabulous article in Forbes. I don't know if you've seen it. And it says that the legal services market is valued at $1 trillion globally and making it one of the largest in the world. And it also states that the law remains profoundly under-digitized, and the field is driven by tradition and notoriously slow to adopt new technologies and tools. I'm quoting from the article. As someone joked, the most important tech tools for lawyers are email and Microsoft Word, which strike through.
True.
So do you think that artificial intelligence, AI, ML are going to change the legal field? There are several activities. For example, contract review, contract analytics, legal, case outcome prediction, legal research, which can, AI can play a role in. AI is changing everything, so why not the law? And why not the legal profession? Not the law, but the legal profession.
So I think it will change up to a point, Kaushal, because ultimately you are paying me for my brain, right? So if my brain can be replicated and that day comes, I'm obsolete. But I think that day is far. So there will be some changes. Second part, at least in India, I can tell you it's a systemic issue.
Right.
So if you come to me and say, okay, do my due diligence on AI, and I said, can I employ AI? You say, fine, you employ AI. And I employ AI. And the due diligence is not correct because they missed certain algorithms or there are certain things. And of course, remember, there is always the Indian brains that have drafted those contracts that way, certainly, except these are not templatized contracts. You're not even having templatized force majeure contracts. That's why these conversations are happening. So when this is not templatized and you have the Anglo-Saxon hangover on the law, now you are suddenly going to get an American version trying to look at it in terms of this thing, and you miss thing, and you buy a thing, and certain liabilities are missed. Then you say, oh, Abhijit, you missed it, so now I'm going to sue you. People don't sue lawyers, but it's happened. Once upon a time, people didn't sue doctors. Now they're suing doctors. We are all unlimited liability partnerships in India. So for all our insurance folks on this thing, we are not even allowed to have LLPs. All you guys can allow LLP, but we are not allowed to have LLP. So I lose my house.
So there's an opportunity for the insurance guys.
Yeah. So, but all I'm trying to tell you is that I lose my house. It's an unlimited liability. So in England, now law firms can go public. So I'm saying there are lots of things that have to be read alongside. Merely because, so you have to change, allow us to limit liability. Then we'll take more risks on the subject because AI is not really rolled out, but maybe 10 years later it'll be more sophisticated because its AI also has to pick up data. It has to map the Indian brain. Because every contract is going to be. So many times people come to us, sir, this is the problem. Kuch rasta dikhao. Find me a way, right? And then you say, but this, sir, aapke paas we've come only because now you find us a way. Now, if AI can find that, very good. So up to a point, yes. But after a point, it's like you go to a doctor. If everything a robot can do, why go to a doctor? Where's the clinical examination?
Okay, Abhijit, we're running out of time. One last question, actually last words that I'm going to ask you to say. Do you see any new standard clauses that are going to come into clauses that are going to come into a standard commercial contract due to the pandemic to protect the parties concerned? And what would such clauses be, if any? So what is your advice? Broadly, what I'm saying, I want free advice for all the people attending this call, Abhijit. What is your advice to them currently in terms of contract drafting, etc., from, to protect themselves?
So first two things, free advice is an oxymoron, but I'll try. There's nothing more expensive than cheap advice, but I'll try. But
I knew you were going to say that, but yeah, okay.
I think force majeure, which did not find place in many commercial contracts because they would typically be in long-term contracts, infrastructure projects, real estate projects. That also half of them didn't have it. So force majeure is one thing that you need to negotiate. Force majeure also, please don't have cut and paste. Apply your mind to say, as I said, the ups and downs of pandemic or something that you learned. For example, before 9/11, terrorism was not part of force majeure.
Correct. Very true.
Yeah. So now, whether it's terrorism, whether it's a biological attack, or whether it's mutation of viruses, or whether it's for example, antibiotic immune, whatever you call it, AMR resistance. So I think you got to think about it and think about it's not a total shutdown or anything. It's like the heart rate. So you got to capture that aspect. That is one. Secondly, I would think on your employment contracts.
Right.
Where your ability to hire and fire should be enshrined in the contract, irrespective of a situation like this. Right?
Yeah, absolutely.
So there are two parts. Capturing an event which is unknown, but has a particular kind of effect. And two, capturing in a bilateral contract preserving the commercial aspect and avoiding trying to more socialistic behavior by the government. Because even if the government, let's say, said that you cannot sack, but you had a contract which said, look, even if you have a legal protection, you agree. Now that may not be exactly enforceable, but if you say, even if you had a legal protection not to get sacked, I still have a right to sack you because this is what you and I have agreed. Now that may not stand the test of law, but at least it stands the test of intention. That
Correct.
This was a willing seller and a willing buyer. A bargain was made at the particular thing. I decided to pay you 100 because we had this kind of a contract. After that, one is just unduly taking advantage of a protection. So your ability to buy your freedom is something that you would want to put into. So these two things that I think I would try and put, at least the learning out of this, uncertain times.
Right. No, in fact, I think, you at the beginning of the pandemic, when we had a similar chat in a different forum, you had clearly said that you were hoping that the courts would sort of go with the letter of the law, the letter of the contract, and not go the socialist way in terms of this. And you had been very categorical about it. I think you've been prescient, and you were borne out as being absolutely correct. Thankfully, they've taken that view. There were several questions around that today. People saying that what do we do in case we need to terminate people, etc. But I think that's now settled, right? Am I fair in saying that it's settled?
Yeah, it's settled. But there is a learning, right? Because there was a time when the government came in and said, you can't sack.
Right.
And what do you learn from this? That you and I can be married forever. Now, there is no marriage which is, there's no concept like that, marriage forever. Everybody has a right to get out. You never get into a room without windows. Even if you want to commit suicide, you must have a window.
Correct.
Right. So, so you got to contractually build all these uncertainties into it. The law may change and make it unenforceable, but still the intention will come out loud and clear.
Right. Abhijit, thank you very much. A brilliant session as always. Someone just put up right now that this is our, I think, 7th session, and someone just said the best session by Rubix thus far. We keep trying to improve, and thank you for helping us improve. It was a great session, and very, very good having you with us today. So thanks for everyone, guys. All those on the call, thank you for logging in. Abhijit is absolutely brilliant, and you can, at any point of time, Veritas Legal would be a great port of call for any serious legal issues that you have. I would like to thank everyone for being on this call. Our next webinar is on the following Saturday, where we are going to be doing a session on blockchain and blockchain in business. So at 11 o'clock next Saturday, you'll have the details. So look forward to seeing you there. Till then, thank you, everyone. Stay safe. Abhijit, thank you very much. Stay safe again.
Thank you, Kaushal. Thank you.
Bye.